It's 2:17 in the morning. The house is silent. Your children are asleep down the hall. The lights are off. Then suddenly, without warning, your front door explodes inward. Boots pound across your floor. Flashlights cut through the darkness. Voices shout, "Police! Don't move!" You're disoriented. Your heart is racing. No one showed you a warrant. No one explained anything. And in that split second, one terrifying question hits you. Is this legal? Or has your Fourth Amendment just been violated in your own living room? Tonight, we're talking about the single most protected space in American law, your home. Because despite what many people believe, police cannot simply enter whenever they want. There are rules, strict ones. And yet, there is one narrow exception, a loophole if you want to call it that can transform what looks like an illegal home invasion into a lawful entry. If you do not understand that exception, you cannot fully protect your rights when officers show up at your door. Over the next few minutes, I'm going to break this down in a way that's clear, practical, and grounded in real constitutional principles. We're going to cover 3 specific situations where police can legally cross your threshold without a warrant. We'll also look at 2 situations where they absolutely cannot, but sometimes try anyway. And before we're done, I'll give you the exact sentence you can calmly say through your door to assert your rights without escalating the situation or risking a charge like resisting law enforcement. Everything in this discussion revolves around one critical legal concept: exigent circumstances. This phrase is the primary justification officers rely on when they enter a home without a warrant. It is powerful, it is controversial, and courts frequently find that it has been misused. Evidence gets suppressed, criminal cases get thrown out. In some instances, officers even lose qualified immunity because they crossed a constitutional line that has been clearly established for decades. So let's start with the foundation, the Fourth Amendment itself, and why your front door is treated, legally speaking, like the gate of a castle. The Fourth Amendment protects your house, your papers, and your effects from unreasonable searches and seizures. Courts have repeatedly described the home as first among equals when it comes to constitutional protection. That's not poetic language, that's doctrine. Your home receives the highest level of protection under American law. As a general rule, police need a warrant supported by probable cause before they can enter. No warrant, no entry. That's the baseline. And this protection doesn't stop at the drywall. It extends to what courts call the curtilage of your home, the area immediately surrounding it. Your porch, your front steps, the short walkway leading to your door, the small yard directly adjacent to the house. These spaces are legally treated as part of the home itself. Now, officers are allowed to approach your door for what's known as a knock and talk. Courts recognize that police, like any private citizen, have an implied social license to walk up to your front door, knock once or twice, wait briefly, and leave if no one answers. Just like a delivery driver, just like a neighbor, just like a Girl Scout selling cookies. But that license is limited. It does not give officers permission to wander around your property at 3 a.m., bang on bedroom windows, shine flashlights through curtains, or refuse to leave after you decline to engage. When they exceed that narrow permission, or when they claim there's an emergency, we enter the territory of exigent circumstances. And this is where most people's rights are at greatest risk. Exigent circumstances is a tightly confined exception to the warrant requirement. It allows officers to enter a home without first obtaining a warrant, but only when there is a compelling and immediate need for action. The kind of situation where waiting even a few minutes could cause serious harm or permanently destroy evidence. Think of it as an emergency override button to the Fourth Amendment. But it's not there for convenience. It's not there because getting a warrant takes time or paperwork. It's there for genuine emergencies. And in just a few moments, I'll give you the precise language you can use when officers are at your door to assert your rights clearly and calmly. One of the main categories of exigent circumstances involves preventing the imminent destruction of evidence. If officers already have probable cause to believe that evidence of a crime is inside your home, and they reasonably believe that evidence is about to be destroyed, they may be permitted to enter without a warrant. Classic examples include hearing toilets repeatedly flushing, shredders running, or someone inside yelling, "Get rid of it!" But the key words here are probable cause and imminent destruction. It cannot be a vague suspicion. It cannot be a generalized fear that evidence might disappear at some point. It must be a concrete, urgent situation where waiting for a warrant would almost certainly mean the evidence is gone forever. The second major category is hot pursuit. If police are actively chasing a suspect who they believe just committed a crime, and that suspect runs into a house, officers can follow immediately without stopping to obtain a warrant. But this must be a genuine, real-time chase, not, "We saw him earlier, and now we know where he lives." It must be immediate and continuous. The suspect runs in, and officers are right behind. There's also a major limitation here. Police cannot manufacture the emergency themselves. If officers aggressively pound on your door, shout threats, or create panic, and then claim they believed you were destroying evidence because you seemed frantic, courts often reject that justification. This is known as police-created exigency, and it does not legitimize a forced entry. Another central category is imminent danger, often referred to as the emergency aid doctrine. Here, the focus is not evidence, it's safety. If officers have an objectively reasonable belief that someone inside is seriously injured or in immediate danger, for example, they hear gunshots, violent screams, or unmistakable sounds of a physical assault, they may be allowed to enter without a warrant to prevent harm or render aid. The key phrase is objectively reasonable belief. Courts scrutinize what officers actually knew at that moment, not what they speculated, not what they imagined after the fact. Judges also examine the seriousness of the underlying offense. Courts are far more likely to excuse a warrantless entry in cases involving violent felonies than in situations involving minor infractions. Kicking in a door over a low-level misdemeanor, like a minor traffic-related issue, is often viewed as an unconstitutional overreach. Even in cases involving underage drinking, where there could be some risk, several courts have ruled that you need concrete evidence of actual imminent harm before bypassing the warrant requirement. Here's where confusion often sets in. Probable cause alone is not enough to justify entering a home without a warrant. Probable cause answers the question, do officers have sufficient evidence to justify a search? Exigent circumstances answers a different question. Is there such an urgent emergency that waiting for a warrant would be unreasonable? If police have probable cause but no immediate emergency, they are expected to step back, contact a judge, and obtain a warrant. Many serious Fourth Amendment violations don't arise from claimed emergencies at all. They come from officers abusing the knock-and-talk doctrine. In cases like French versus Merrill, officers repeatedly returned to a home in the early morning hours, pounding on doors and bedroom windows, shining lights inside, and demanding occupants come out. The court concluded that this behavior far exceeded the implied social license to approach a home. No ordinary citizen would believe they have the right to circle someone's house at 3 a.m. banging on windows. Police do not gain that authority simply by wearing a badge. So what does all this mean for you in practical terms? There are 2 rules you must remember. First, you are not required to open your door. If police knock and do not present a valid warrant or clearly demonstrate a genuine emergency, you have the right to remain silent. Simply declining to open the door does not create an emergency. Your refusal to engage does not justify forced entry. Second, if officers claim exigent circumstances and enter, their actions must be justified and narrowly limited to the emergency at hand. They must later demonstrate in court that they had an objectively reasonable basis to believe an urgent situation existed and that it could not wait. So, what should you actually say if officers are outside? If it is safe to do so, and ideally while recording, you can calmly state, I do not consent to entry or search. I do not believe exigent circumstances exist. Please provide a warrant. You are not arguing. You are not escalating. You are creating a clear record. And here is the most important safety warning of this entire discussion. Even if the entry is illegal, do not physically resist. I understand the instinct. If strangers storm into your home, your body wants to defend itself. But the legal battle happens later, in court, not in your living room. Physical resistance can result in serious injury or additional criminal charges. The proper recourse is filing motions to suppress evidence or pursuing civil rights litigation. Courts have stripped officers of qualified immunity when they unlawfully entered homes because the law in this area is clearly established. Exigent circumstances is a powerful doctrine, but it is supposed to be rare. It has strict boundaries, and understanding those boundaries is one of the most effective ways to protect yourself and your family. Your home is not just where you sleep, it is where the Constitution is strongest. If you've ever experienced police knocking at your door or something more aggressive, share your experience. Conversations like this matter because knowledge changes outcomes. Stay informed, stay calm, and remember, your rights don't disappear just because someone is knocking.